doubt in their mind at all about whether it should be granted. Finally, don't forget that that motion is still sitting out there at the end of the case, and remind the judge that he has to rule on it. The other common motions that come up during the course of the trial are the motion to amend your pleadings to conform to your proof. This will often happen, as the judge said. The prayer that you've asked for in your complaint has nothing to do with what you've been able to subsequently prove. This is true more in the personal injury field than it is in the commercial litigation field, but even so, we get in there and sometimes find that our clients either come up with more bills that are due or credits that weren't issued, and it's a fairly common amendment, a motion to amend to conform. And this can also be done to conform the answer to the proof that was raised on the defense side. And finally, of course, there is a motion for a mistrial. As we talked earlier, if in the chambers conference you disclose who your witnesses are, and you don't suddenly discover that you've got your expert as the judge's brother-in-law, it's very uncommon to see a motion for mistrial. If you do find one, you're usually going to be talking about surprise that could not have been presented through ordinary diligence. And one of the things you have to consider about that ordinary diligence is the nature of your pretrial discovery, which will come into effect to see if you were ordinarily diligent.
I can't recall ever granting a motion for a mistrial. The motion is very rarely made, and on the rare occasions that I have had it made, it has been, as Richard suggests, proclaimed surprise, and I have, on those occasions, either found that there was no legitimate reason for claiming surprise, or have offered a continuance as an alternative, because we, of course, don't like to lose the time that has been spent in developing evidence up to the point where the motion is made. Warren, will you tell us about the proper use of closing argument in a short cause?
Again, the general rule that in a short cause matter, the closing argument is not really going to tell a judge anything that he hasn't heard. But what you do want to do is to use that closing argument to hit the testimony that supports your position. And it gives you a chance in a family law matter, again, to argue the equities of why you want what you want, why it's reasonable and fair, and of course in your client's best interest to have a decision made in a certain way. The form is brief, concise, and tight. The judge has only been sitting there for the day. He doesn't need you to review all the facts and go through it again. You're not going to score any points for him to do that. But let's switch again to the family law matter for just a moment. You're going to have a number of issues that you presented to the court. You're going to want the judge to make certain rulings on each of those issues. As I've indicated before, some of them are related to each other. If the judge goes one way on one point, it's going to follow necessarily that certain other issues must also go in a predetermined direction. My hope is to use that closing argument to get the judge to take a position on a contested issue. If we can get the judge's leaning on one particular point, it could very well be that's in the best interest of both parties to ask the court to put the case on pause, to take a brief recess, to get with other counsel, and then take a look and see what you can do if you assume the judge is going to make a ruling on one key point, and those things that must logically follow should be presented to counsel so that you can discuss the tax effects of what's going to happen. If the court goes ahead and makes that decision, you could very well be locked in the tax effects that could be very disastrous, and the only real beneficiary of the decision will be the government, who could very well have substantial funds paid over out of the funds that are really belonging to these parties because of the way the decision came down. Once you explain to the court what the tax effects are of those various alternative decisions, I believe it's a rare circumstance that the court won't give you an opportunity to try to come to some kind of a settlement once you know which way he's going on that key issue. If you don't ask the court, you're really doing a disservice to your client, because you've hung the client out to dry on a point that you could have done something about that doesn't have to come out of the pocket of the other side. Judge, if you're presented at the time, at the end of the case, before it's really submitted to you, and a request is made for a TH in a family law matter. Have you ever, or would you consider giving us your leanings on that issue so that the council can go to work out a settlement that will take that into consideration?
Oh, yes, I have been asked to do that, particularly in domestic relations cases, and have done it, but I think it's preferable to, in your in-chambers conference at the commencement of the case, reach agreement that that issue is going to be the critical one on which all the others are likely to turn or be resolved, and then simply bifurcate the case in effect and present that one issue and let the judge decide it. And if you want to recess and try to reach agreement with that in mind, that can be done. And I have done that a number of times, and it has shortened cases greatly.
I think the main point is that short cause matter can be presented as short cause matter, but if the decision goes one way or another, it could very well have significant effects that you can't produce in advance, so that once you know where it's going to go, then is the time you get to work with that other counsel. So the efforts to settle are not necessarily over merely because you put all that testimony on. Don't waste it by letting that final decision come down that you can't move away from. Your goal is, again, to reach a conclusion that's satisfactory to your client in your client's best interest, and not necessarily to defeat the other side. Your objective is to focus on your client's interest. When you've used the court to evaluate the facts and come up with those conclusions that you and the other counsel couldn't agree on, then you've really gotten the logjam broken. And those issues can be put together in a way that benefits all the parties, avoids appeals, and avoid yourself getting sued.
We again remind you that accompanying this tape is the printed softcover booklet